Hi, good afternoon if you're in the east, and good morning if you're in the west. This is Lacey with Thompson Coburn. Appreciate you all tuning in to the fourth in our 5 webinar series, Navigating Gainful Employment. So I mentioned this is the fourth in our series of 5, Preparing for and Managing Required Student Warnings. My name's Lacey. I'm a partner in the higher education practice of Thompson Coburn LLP. It's a law firm, we are a law firm of about 400 attorneys based in St. Louis, but we have offices elsewhere like DC and Chicago and Los Angeles. Our higher education practice provides a range of services, which I tend to divide into sort of 3 buckets. We do regulatory advising and counsel on federal, state, and accrediting agency laws and standards. So that's Title IV, Title IX, the Clery Act, ADA, consumer information, all those kinds of things that affect institutions of higher ed. We assist institutions with a wide range of transactions and contract and policy design and negotiation. We help folks create compliance systems, handbooks, all those kinds of great things. And we represent institutions in adversarial proceedings, so whether that might be student-employee litigation, government investigations, administrative proceedings with the Department of Education, or accreditors, program reviews, things like that. So that you know, before I was with Thompson Coburn, I spent about 4 years in-house overseeing regulatory affairs and development for a post-secondary institution with 24 campuses and an online division. So I was in-house. That was from 2010 to about 2014. I went through Gainful Employment 1 while I was on the inside, and went through program reviews and OCR investigations and IG investigations and all those kinds of things that come with being in a large for-profit post-secondary institution, or have in the last few years anyway. And before that, I spent about 8 years as an attorney in the higher education practice of another law firm in Washington, D.C. All right, so here's our webinar schedule. That's the 5, and you see number 4, which is what we're doing today, is highlighted in, or bolded in red, I should say, Preparing for and Managing Required Student Warnings. Here's the outline. So as always, I'm going to start with the GE timeline briefly. Then I want to talk about, again, very briefly, the connection between the DE rates and the GE warnings. And then we're going to talk about warnings for prospective students, warnings for current students, and then some additional considerations. So, just some things that I thought you would want to think about, and some additional questions I thought might come up. And finally, we'll go over our GE resources as always. Okay, so the Gainful Employment Timeline. So the 2015 is the first slide here. You guys know this is stuff that's already happened. These regulations became effective July 1. You reported a great deal of data to the department if you were with a school on July 31 and then subsequently October 1st of last year. And about November of last year, there was an opportunity for folks to register for to receive the completers list through the SAIG enrollment website, and also to enroll in the department's new Data Challenges and Appeal Solutions service. When we send out the slides for this presentation, which will go out after, these links are active, so if you still haven't registered for these things, please, you can do so. And these were both things that we talked about in our session last week when we went over the various kinds of challenges that you'll be able to lodge this year. December 31 of last year was the deadline to complete the GE transitional certification. If you have not done that yet, I recommend that you do it now. This year, the real story, and again, this was the topic of last week's webinar, this year the real story is going to be all your opportunities to challenge the debt-to-earnings data that the department has and will be using to calculate your first round of official rates. You've got the completers list challenge opportunity in the spring. We think, unless the department is further delayed, later this summer, early fall, you'll have an opportunity. You'll get the draft rates. At that point, you'll have a chance to do a couple of things. One is to challenge the loan debt information for the students in each cohort, and the second is to begin, if you want to, preparing an alternative earnings appeal. And then in 2017, two things are going to happen. Well, a lot of things are going to happen, but two things I really want you to think about today. One is in January, immediately the new GE disclosures are going to become effective. Now, we're going to talk about the disclosures in our next week's webinar, which will be the final in the series. We're going to talk about these new disclosure requirements. But the other thing that's going to happen, we think, in winter, spring of 2017 is that we'll see the issuance of the final DE rates, which also means it's the first time that someone could learn that a program failed for round one, right? And when that happens, at the same time, it will trigger a requirement for any program that failed in 14-15 to begin disseminating the student GE warnings, right? And that's what today's session is about, is what that means, what you'll be required to do, and some thoughts about how you might want to prepare for that if you think you're going to have a program that fails in year one. All right, so what's the relationship between the DE rates and the GE warnings? I just alluded to it. As you know, we've discussed several times, there are two debt-to-earning rates that the department is calculating for each gainful employment program that you offer. The first is the annual earnings rate, which is the annual loan payment over annual earnings. The second is the discretionary income rate, which is your annual loan payment for the program over discretionary income. So for each GE program that you offer, the department is going to calculate these two rates. If your rates pass, right, for your program, you're fine. Right? But there are two other alternatives. One is you could be in the zone, and that happens if your rate for your AER is greater than 8% or less than or equal to 12%, and the DIR is not passing. Or conversely, if your DIR falls between 20 and 30 and your AER, or annual earnings rate, is not passing. In either one of those cases, you would be, quote, in the zone. If you fail both with regard to your annual earnings rate and your discretionary income rate, then the program would be deemed failed for that year. That doesn't mean it's ineligible. It just means for 14-15, that program's rates failed. So what does that mean? When does a program become ineligible? If a program fails 2 out of any 3 consecutive award years for which DE rates are calculated, it would become ineligible. Or if the program has a combination of zone and failing rates for 4 consecutive award years for which the program's DE rates are calculated. So this is the ineligibility issue that arises if you have a GE program that is failing or in the zone for too long a period of time. What we're going to focus on today is the other sanction that can relate to DE rate performance, and that's the GE warnings. So when must a school issue a GE warning? If the department notifies you that the program, your GE program, could become ineligible based on its final DE rates for the next award year. So in other words, if there's a possibility that a year out, when the next rates come out, your program could lose its eligibility, at that point, you've got to start making the GE warnings. And the purpose of this device or this regulation, if you think about it, is to try to ensure that students are aware of the potential loss of funding at least a year in advance, so that if you've got a current student or someone enrolling, they know that a year out from that point in time, they could potentially lose access to Title IV. The disclosure obligation, I'll note, is triggered by the notice received from the Department of Education, right? So even if you think you're going to fail, if you've received draft rates, that's not what triggers the GE warning requirement. What triggers it is the notice from the department that the program has actually failed and that they believe you are a year out at that point from potentially losing eligibility. My speculation, this hasn't happened yet, but my speculation is they will have a standard type of notice with some canned language, and they will know based on the prior year performance whether or not you are at that threshold, so that when they issue the notice of determination for a given year, so when they send you your official rates, DE rates for a given year, in the body of that notice, my expectation is they will also notify you at that point in time that you need to start making these warning requirements. So in that case, it would work a lot like a CDR notice or something like that, where you get the official rates, and it also has canned language about potential sanctions and things like that, depending on what the rate is in prior year history. So I want to take this today in 2 big buckets. The first is prospective students, and the second is current students, enrolled students. When you have to start making the GE warnings, you've got to provide those warnings to both, but the requirement relating to the contents of the warning and also the process of distribution varies a little bit in terms of the law, and I think operationally it's going to vary a lot. In other words, when you go about actually implementing these requirements, you're probably going to think of these things very differently. At least based on my experience in-house, I think that I would. I mean, in the one case, you're talking about the admissions workflow, right, and disclosures that have to be made in the context of admissions and enrollment. And in the other case, you're talking about dealing with existing students, and that would probably be handled through an education vertical by potentially a very different group of people. So for a number of reasons, not only because the law and requirements are different, but because I think operationally these may fall in different verticals, I think it makes sense to think of them separately. So what's the definition of a prospective student? The department, for purposes of GE warnings, the department defines a prospective student as an individual who has contacted an institution to request information about a GE program or who has been contacted directly by the institution about the GE program. A couple of things I want to point out here. I mean, one is the definition goes both ways, so it doesn't matter if the prospective student reached out to you or if you reached out to the prospective student. But I will note that at least with regard, and I'm not trying to be cute here, but with regard to this definition, it focuses on the GE program, right? So in theory, if a student reached out to you just to talk generally about your institution, or if you reached out to or had some third party that reached out to an individual to talk generally about the institution and not a specific program, there is an argument that that person would not be a prospective student for purposes of this GE warning and notice. And it is possible that some of you, with regards to certain types of marketing or third-party recruiting relationships, that initial contact would really be quite generic and only at the institutional level and wouldn't get into the level of a GE program. Again, I'm not trying to be cute, and I think you want to take a conservative view, but it is something to keep in mind that these warnings and a lot of the requirements surrounding the warnings, and as you may recall, a number of the requirements relating to just generally the gainful employment disclosures that have to be made only attach when the conversation is about the GE program and don't involve general marketing or advertising or conversations about just the institution on the whole, right? So that's just something to think about. And even here, they've been careful to say that it's about the GE program. It excludes indirect contact through advertising. So again, that's going to that point I was just making. If you're sort of, if you have general advertisements on the web or you have general advertisements, if you have a billboard or something like that, that would not be contact with a prospective student obviously for purposes of the GE warnings. But, and this is important, it includes contact made by a third party on an institution's behalf. So if you have subcontracted out some level of your marketing or recruiting activity, and that involves a third party speaking with a prospective student about the GE program, that would be covered. And that would be considered, that person would be considered a prospective student, and as we'll discuss later, that would be considered relevant contact. So that is something to keep in mind here. You're going to have to think about not just your direct activities with students, but also whether you have relationships with marketers or third parties that are doing recruiting on your behalf that could be impacted. What is the content of the GE warnings for prospective students? Okay, so there are two critical things that have to go into the GE warning when you're talking about prospective students. And as we'll see in a little bit, there's a lot more you have to put in when you're talking about current enrolled students. But for prospective students, it's two things. The first is the warning document has to refer them to and include a link for the Department of Education's College Navigator website or some similar federal resource for information about similar programs. So it's not just a link generically to College Navigator, right? I mean, they want you to figure out a way to link to some portion or segment of College Navigator that would have information about similar programs. At least that's how I read the law. Maybe the department will back off on that. You could take a more liberal interpretation and say, well, really, I just need to refer them to College Navigator. The conservative interpretation would be that you really should be trying to figure out a way to point them towards information that is about a similar program. The second thing that the warning disclosure has to include is a verbatim statement that's included in the federal regulations. And I've put it on the next slide. I've had people ask me, though, on a number of occasions, is there some variation here? It is verbatim. It's straight out of the regulations. and it needs to be presented just this way. And this is what it says. This program has not passed standards established by the U.S. Department of Education. The department based these standards on the amounts students borrow for enrollment in this program and their reported earnings. If in the future the program does not pass these standards, students who are then enrolled may not be able to use federal student grants or loans to pay for the program and may have to find other ways, such as private loans, to pay for the program. Now, we could argue with a number of the things that are being said in this statement. I mean, just off the top, being a technical guy, I note that it says the department based these standards on the amount students borrow for enrollment, maybe unless the department was taking the cost figure, the cost assessed figure for your program, right? Because when they really do the rates, it's either the lesser of the cost assessed or the debt number. So right there, I mean, you could make some technical arguments that this disclosure is not entirely accurate. But I will say one thing the department has done here, which I think, this is cold comfort, but that I think is beneficial potentially, is they're not saying or suggesting that you will no longer offer the program, or that the student will no longer be able to offer the program, or that the program will be shut down, or that the school will be shut down. What they're saying is you won't have access to federal funds, and as a consequence, you may have to come up with some other way to fund your program, right? Which is accurate, and stop short of saying your school's going to close and you'll be totally out of luck. So at least there's that cold comfort here. But you see why, looking at this language, and if this is the first time you've seen this, you're probably immediately understanding that this is going to impact admissions and enrollment activity when you put this disclosure in front of folks. And that's a big reason why I wanted to do this webinar specifically on this topic, because I think it is worth taking some time this fall to think through how these warning disclosures are going to integrate into your admissions and enrollment and educational processes, so that you can distribute them in a way that is accurate and complete and consistent with the law, but doesn't result in unnecessary damage. Okay, when must the GE warning be delivered to prospective students? So the good news is when it comes to prospective students, the content is pretty simple, right? It's just that reference to College Navigator, and it's that CAN statement. It's just those two things. The bad news is the distribution requirements for prospective students are kind of complicated. And this is one of those areas where I think it will behoove you to give some real thought to this when you're trying to decide how to integrate it into your system. So there are really sort of three timing rules that surround providing this disclosure to prospective students, and they all are operating at the same time. Think of it sort of like a triangle. So you've got three walls, and you've got to figure out how to do this within the bounds of those three walls. The first is you have to provide a written or, this is important, written or oral GE warning to prospective students or to a third party acting on behalf of a prospective student. So if you have a parent or someone else who's calling on behalf of, a brother or sister, et cetera, calling on behalf of that prospective student, at first contact about the program. All right, so if the student reaches out to you, if they call you, remember we talked about the definition of a prospective student. If you've got a third party reaching out to prospective students, at that point of first contact about the program, a written or oral GE warning has to be made. Again, and I've got this in the smaller bullet, it has to be carried out by the third-party marketers if they're the ones having first contact with prospective students. So, and this is a piece of legal advice to you guys, or I'll say it's advice from a lawyer type, consider including that as a requirement in your marketing agreement. So if you've got written arrangements with folks who are marketing or recruiting on your behalf, right, you might want to modify those arrangements to specify and make clear that those persons will be carrying out this activity on your behalf and making this first contact. Further, you might want to contemplate an indemnification provision that says if they fail to do that and for some reason there's some sort of financial loss or penalty, that they're going to indemnify you for it. So something to think about. So, but again, the first timing rule, I'll call the first contact rule, right? And it just means that when you have first contact with this prospective student or someone acting on your behalf does, or a third party acting on behalf of the prospective student, you got to make sure that you're making this disclosure in either a written or oral format. Timing rule number 2, you have to provide a written GE warning. So you can't do the oral here. You have to provide a written GE warning to a prospective student or third party at least 3 days before the institution enrolls, registers, or enters into a financial commitment with the prospective student for the program. Right? So in other words, let's just think about this for a second. Let's say someone gives you a call, right, and you chat with them and you make orally the GE disclosure. And if you make it orally, that means you got to read that canned statement word for word. But let's say you make it over the phone, right, and then that person says, okay, I'm going to schedule time and I come in and we'll do all the paperwork and sign the enrollment agreement. Well, now you still need to make sure that you're getting a written GE warning to them, right, in advance of signing the enrollment agreement. And if you don't get it to them before the day that they show up for their appointment, then after they sign it, you're going to have to wait 3 days and then have them come back. This essentially works as a cooling period, right? Because you have to make the written warning. It has to get to them at least 3 days before they sign the enrollment agreement. So already you can see how it makes sense to think about how you want to operationalize these requirements in the context of your admissions processes. And here's timing rule number 3. If more than 30 days have passed from the written GE warning, all right, then you have to provide a second GE warning, and you have to wait another 3 days before signing the enrollment agreement. So let's say theoretically you've got someone who calls you, right, and you talk to them, and you make it the first time orally, okay, and you schedule an appointment for them to come in a month later, right? But for whatever reason, you forget to make the warning in writing before they show up. So they go through, everything. They go on a tour. They ask all the questions. They meet with an admissions representative. Everything's great. And they say, okay, I'm ready to sign an enrollment agreement. Or for those of you who don't use enrollment agreements, nonprofit public institutions, they're ready to register or go ahead and make a payment to the institution. You won't be able to do that because they didn't get the written disclosure. So now you make a written disclosure to them, okay? And you have to wait 3 days. But let's say they don't come back in the 3 days and it takes another month to get them back in the door. Now you've got to make it again, right? And then you'd have to theoretically wait another 3 days if you didn't get it to them until they came back in for the second appointment. So putting into place a mechanism that will permit you to sort of track those timelines and potentially get the written disclosure to folks at least 3 days in advance of the scheduled appointment, also to try to make sure that the 30 days don't go by, can mean the difference between making one written disclosure early on or having to make 3 or 4 of these disclosures over and over, right? So it makes sense to give thought to the timing. Okay, how may the GE warning be delivered to prospective students? Okay, first of all, as we said, you can provide the GE warning orally by telephone, but that only satisfies the first contact rule. So the institution may not actually enroll, register, or have the student enter into a financial commitment based solely on an oral warning. If you do provide the oral warning over telephone, maybe the easy way to operationalize this is you say, hey, I want to make this oral warning to you, and I'm going to shoot you an email afterwards that has the same thing in the email. And I'll talk about the email stuff in a minute. But, maybe you get all that done right away in the context of the initial conversation. But just remember, the orally only works for the first contact rule. You can hand deliver a GE warning as a separate document. Okay, so it can be delivered individually or as part of a group presentation. So in theory, if you had a group come in for some sort of orientation or open house or something like that, and there was some way that you could integrate the warning into that process, you could do it to everyone in the context of the group. Another important note: you can use the Gainful Employment Disclosure Template, the GEDT, as long as it includes the warning language, and it probably will. There is a separate regulatory requirement in the law after you receive notice from the department that your program may lose eligibility a year out, right? So basically you've received a notice saying it's possible you could lose eligibility a year from now and you've got to start making these warnings. You are under a legal obligation to go in and update your Gainful Employment Disclosure Template with the GE warning within 30 days. So you've got the template that's already out there, and if you were in this position where you had a program that failed in year 1 or was in the zone 3 years in a row, for example, then you've got to go in and update your template anyway to include the canned language. What I don't know right now is if they will also modify the template so that it will permit you to put in the reference to College Navigator. If it did, then in theory, the GEDT would have both of the required disclosures, the reference to College Navigator and also the canned language, and that could serve as your disclosure. Now, I'm going to discuss later, I think incorporating the GEDT template is useful, but I think there's a lot of opportunity for folks here to package it with other materials that may be explanatory or offer assurances or context relating to the DE rates, and you may want to do that. But the salient point here is, after you find out that you're going to have to make these warnings, right, you're going to have to update your GED template anyway, and you can use it in connection with making this disclosure. You should obtain written confirmation of receipt, and I'll discuss later there are a number of ways that you could do that, but you're definitely going to want to do it, because if you don't, you're not going to have any way to document compliance. The other thing you can do, so you can make, for purposes of first contact, you can make that oral disclosure if you're on the telephone or something like that, and that will probably be the case for a lot of people, okay? And then for purposes of the written disclosure, you can either deliver it in hand or you can send it via email, and I'm sure a lot of people will do this. You need to send it via email to the primary email address used by the institution for communicating with a prospective student about a program. So what's interesting is, that means if you're in the context of a first contact scenario, so let's say somebody walks through your door at the campus, you're not on the phone with them, you've never talked to them on the phone, the first time you've connected with them is when they walk through the door. And of course, you could just hand them the disclosure in person, but if you wanted to email it to them, say, while they're there, you say, well, I'm going to email you some documents for you to review later, that kind of thing, you're going to need an email address for them, right, to be able to carry this out. Or if you're on the phone with them and you have a first contact scenario and you want to follow up, you're going to need to get that email address right away and get it into your system if you intend to execute these disclosures via email. So just remember that. If you send the warning by email, and you can do that again, you could include a copy of the GEDT. I mean, that's one way you could package your warning. You have to comply with some pretty specific distribution requirements, right? And I've got those on the next slide, but I just want to reiterate this. If you're going to use email, there are a number of specific distribution requirements that go along with using email as your means of disclosure. So here they are, and they sort of fall into 4 buckets. One, you have to ensure the warning is the only substantive content in the email. Now, if you've added a cover page or something that has additional information that relates to the warning, I think that's fine. But what you can't do is you can't package the warning along with your catalog, and an enrollment agreement or a bunch of other disclosures and, that kind of thing, your annual security report. I mean, the email, at least for purposes of the GE warning, needs to only have documentation that relates to that warning. You need to obtain an electronic or written acknowledgement of receipt, right? And that's from either the student, the prospective student, or for the third party operating on their behalf. Because remember, this could be a scenario where you're dealing with a third party like a parent. But one of them needs to provide you with electronic written acknowledgement that the email was received. If you try to send it via email, and it gets bounced, in other words, you get that the address isn't valid or something like that, then you are under an affirmative obligation to send it using a different email address or some other method of delivery, right? So that's if you get a failed delivery response. And finally, you got to maintain records of your efforts. So, you need to have the record of the first email package that went out, then you need to have the record if you had the failed address or you got the written acknowledgement of receipt, or if you sent it out and it failed and then you decided to send it through some other means, you've got to have that documentation as well. So one of the things that you want to do, obviously, you don't want to wait until January or February of next year when you find out that you've got a program that failed to be thinking about this for the first time. You want to give some thought that, how are we going to manage this? How will we record this stuff when it goes out and comes back? All of those kinds of things. So you'll be ready to go, and you won't be figuring that out while also worrying about how it's impacting your admissions efforts. Interestingly, the law does not allow an initial warning attempt to be sent using U.S. Postal Service mail or commercial courier service. So I just want to point out again, you got 2 options. One is hand delivery, the other is email, and they were pretty specific about that. And interestingly enough, sending it by snail mail or registered mail or anything else isn't okay. However, remember on that prior slide, I said you're allowed to use other means if you tried via email and it didn't work. So if the institution receives a response that indicates that the original email attempt couldn't be delivered, then you can send the warning using a different address, different email address, or a different method of delivery, and that can include U.S. Postal Service or commercial courier service. So those are acceptable fallbacks, but they're not acceptable as first-round efforts, sign of the times. All right, so let's talk about distribution of GE warnings to current students. I mentioned earlier that one of the big distinctions between prospective and current students is the content of the actual GE warning disclosure. So the GE warnings for current students have to include the College Navigator referral link, which is the same as for prospective students, and they also have to include that verbatim disclosure, which again is the same as for prospective students. But there are 4 additional things that need to be addressed in the disclosure materials that you provide. I think you can use the GEDT disclosure as part of this package, but I think, at least my speculation is, it is unlikely they're going to modify it in such a way that all of these requirements could be met. So I think that for current enrolled students, when you make the GE warning, you're probably going to have to fashion some sort of homemade disclosure that accompanies the GEDT, right? So this would be something that you've drafted or written up, or had somebody like us write it for you. So you've got the Navigator link, the verbatim disclosure. In addition, you have to indicate whether the institution would continue to provide the program without Title IV so students could complete the program. You're not under an obligation to do so, by the way. I want to be clear about that. So the department isn't saying that you have to keep offering the program or you can't. They're just saying you should indicate when you distribute the GE warning to current students whether or not you believe you will be able to provide the program without Title IV eligibility so that students could complete it. You need to indicate whether you would refund any tuition fees and other required charges already paid by the student or somebody on their behalf if your Title IV eligibility for the program was lost or if the program was no longer offered. Right? So again, what the department is trying to do is they're trying to get institutions to offer students some information about how the institution would respond if indeed the program became ineligible. And so the first piece is, will you even keep offering the program? And the second piece is, would you refund any tuition fees or other required charges? And that's going to be an institution by institution decision, and totally depends. And it doesn't even have to be the same decision for all your programs. You may offer some clock hour program where it would make no sense to do that, and students can very easily go to another institution, pick up the last 20 or 30 clock hours, and a refund just wouldn't be reasonable. You may also offer a credit-based program where you feel like this might be acceptable, some sort of refund of tuition fees. Incidentally, if you do think you will do that, you need to obviously make sure that you're disclosing that through the GE warning, but you also want to think about how that relates to your standard refund process and the statements that are made in your catalog and elsewhere regarding refunds and things like that, and any state requirements regarding refunds. Describe academic and financial options that would be available to students to continue their education in different programs at your school. So we're not talking about at other schools, we're talking about at your school, but maybe in a different program, including which credits would transfer. So maybe you offer 2 or 3 programs that are very similar, and one of them looks like it's going to have trouble or it's failing and may lose Title IV, but all the gen ed credits that they've taken would transfer, maybe some of the other things that they've taken. I've worked with schools that have, for example, career schools that have HVAC and electrical and a number of trades programs where there could be a lot of overlap in the programs and courses that are being taken, and it might be that there would be an opportunity for a student, even within your school, to move to another program without losing a lot in the way of credit. And finally, the department wants you to explain whether students can transfer credits to different institutions. So some of that I'm sure is already addressed in your catalogs, but and other disclosures, but they want that discussed in the GE warning as well. And that should probably be, I haven't seen this in the guidance, but my expectation is the department would like that to be, if possible, program specific. In other words, you're not just saying, yes, credits, from our school are generally accepted at these 3 schools, sort of like your articulation agreement disclosures and things like that. I think the idea is to say, if you're in our medical assisting program, school X across the way will accept credits. That is not what the law requires, but my expectation is that is what the department is thinking. That would be the conservative approach anyway. Distribution to current students. So I mentioned earlier, the general trigger for having to make a GE warning is when you are potentially, or your program is potentially a year out from losing eligibility. Getting a little more specific, you have to deliver the GE warning to current students no later than 30 days after the department's notice of determination, and that's the date on the notice of determination. And what's interesting is that's a little different in the law. Earlier I mentioned for prospective students there's a timeline that keys off of when the notice of determination was received. And that's how the language in the regulation is written. Here it's actually written to say the date of the notice of determination. It'll be interesting to see if the department shows some flexibility there, but I just wanted to point out at least the regulatory language here does tie it to the date of the notice. So if for some reason you don't receive it for 3 or 4 days, or you forgot to look at your SAIG mailbox or wherever this thing is distributed, that timeline ostensibly would be running. But you need to provide the GE warning to all your current students within 30 days of the date of the notice of determination that your program is possibly within a year of losing eligibility. How may the GE warning be delivered to current students? Okay, so it has to be delivered in writing. There's no oral option here. Now, obviously, you can present it, in a classroom or something like that, hand-delivered, and you can package it with oral discussion, but the disclosure itself and the required elements that we just went through need to be in writing and need to be provided in writing. And the two options are the same two in-writing options that are available to distribution to prospective students. So the first is you can hand-deliver the GE warning as a separate document, right? Again, that can be done individually as part of a group, and you need to obtain written confirmation or receipt, again, if you do that. You can also send an email once more to the primary email address, and again, if you use email, the 4 conditions we talked about apply, those special distribution requirements. So, it needs to be the only substantive content in the email. You got to get a written acknowledgement or receipt. If you get something saying that the address didn't work, you need to show that you tried other methods of delivery. Some folks have asked me, by the way, well, how long do you have to keep trying through these other methods of delivery? How many different times do you have to go? And if you can't ever get the student via email to send you acknowledgement of receipt, what should you do? I haven't seen anything yet from the department about how many attempts you have to make, but what the law says is you can't enroll the person until you've made that GE warning and you've got evidence of receipt. So if it doesn't work via email, okay, but ultimately they're going to have to show up in person and you're going to have to figure out a way to get it to them in writing, right? So I don't think there's anything in the law that says you have to send them 32 letters or keep doing it over and over, but the point is you can't enroll them until the GE warning has been made in writing, right? So you're going to have to figure out a way to do that. And finally, once again, maintain records of your efforts to provide the warning. I mean, this is a legal requirement, but generally speaking, from a compliance perspective, you're going to want to make sure that you've got some way to show that you've been hitting these disclosure requirements. And once more, the law does not permit for the using snail mail or courier service for the initial effort, but you can do that afterward. Additional considerations regarding GE warnings. So if I don't like the prescribed GE warning language, is there anything I can do to change it? Not at present. Not at present. I mean, that can language is in the law, but, and this is also in the law and has been confirmed in guidance, the department intends to pull consumer groups together and they're going to seek input from stakeholders regarding possible future modifications to the warning. Now, of course, that could go two ways, right? I mean, if they get a bunch of feedback that suggests that the warning is not detailed enough or strong enough, they could decide to modify it in a way that makes it longer and more difficult. On the other hand, it does mean that there, at least in theory, should be an opportunity for institutions to say, look, these elements of the warning are problematic or they don't work, et cetera. They're creating issues for us that are unnecessary, and we think that this language should be changed. What if I have students who speak other languages? So what the department has said, and this is actually in the regulations, it says to the extent practicable, and I don't have any, there's no guidance and I can't offer you anything, anything as far as how the department interprets that word. But that is the word in the law. To the extent practicable, institutions must provide alternative versions of the GE warning to prospective and current students for whom English is not their first language. Now, I think you're going to have to this is just going to have to be sort of a reasonableness test. I mean, if you don't know that a student's first language isn't English, or if, a student speaks perfectly fluent English, I don't think the department's expectation is that you're going to figure out what their first language is and then craft this disclosure in that language, particularly if it's not practicable, right? But if you operate a school where you have a large percentage of international students or individuals who predominantly speak another language, I think in that case the obvious expectation is that, if you have a large Spanish-speaking population, that you'll have a version that's available in Spanish. Right? Or if you cater to, I was working with a school not too long ago that had a very large Russian population. It was a significant percentage of the students that they enrolled in. In that case, my guess is the department would probably expect that you figure out a way to translate it into Russian, and they had a lot of folks who were bilingual and spoke Russian and English, so presumably that would be practicable. Right? I think this is just one of those things where you're going to have to use common sense. But if you can do it and you've got folks that need it that way, then I would make an alternative version. And by the way, make sure that you keep a copy of that alternative version. Right? Do I still have to make the disclosure to current students if my program is less than a year? This was a question that came up in the preamble to the final regs. And the department said yes. Our expectation is that you still would make it. But they note, and it is true, that the CAN disclosure says, that is the CAN language for the student warning, says that it's possible a student could lose eligibility it says students who are then enrolled may lose access to Title IV. So even though you still have to make the warning, right, if you've got a student who only has 6 months left in their program, right, or a prospective student who is enrolling in an 8-month program, right, then you could tell them, and this also goes to sort of adding context, that it is not possible, assuming they complete in normal time, that you would lose Title IV before the point at which they would complete, right? That's a factual statement. It's not misleading, and I think that's sort of what the department is saying is here. You still need to make the GE warning, but look, even our CAN language notes that it would only impact folks who were then enrolled, right? So you can try to address that with the student or prospective student, but you do still need to make the disclosure. When can we stop making the GE warning? Okay, so let's say you've had to make it, you failed a year, but you're doing well now, you think your DE rates are going to be pretty solid going forward. It's at the point at which the trigger, the 1 year out from a potential loss of eligibility, ceases to be true. So as long as you are in a state where potentially you could still lose eligibility a year out, right, then you're still going to have to make the warning. What's interesting is I haven't seen anything from the department that suggests that the warning needs to be updated in real time. So, for example, if you're making it at a point when folks are a year out, that's a little different if you're making it to folks who are a month out from when you could lose eligibility. But, that's something you're going to have to adjust for in the context of your conversations with the student. Because the canned language in the disclosure doesn't seem to address that. In other words, it doesn't include some sort of moving date that says, and the eligibility would potentially be lost on date X. And part of the reason I assume that that's impossible, at least right now, is because we don't even know when the department's going to come out with final rates. It's a moving target. But that's just something to consider. You don't want to hand something to a student that suggests that Title IV will be in place for at least a year when it's possible that the second failing DE rate could be out within the month, right? Otherwise you could potentially be setting yourself up for some sort of student claim. So you want to make sure that you're at least taking that into account. And just remember, it's not necessarily packaged in the GEDT template or in the canned language. So giving you a few examples, though, about when you could stop making the GE warning. So if just thinking it through, if a program failed in the first year, so let's say early 17, you get something that says, yes, you failed year 1, and then you passed in year 2, you would still have to make the disclosures. Because remember, the standard is you lose eligibility if you fail 2 out of any 3 consecutive years. So even after passing year 2, you are still potentially a year out from losing eligibility. So that condition of being a year out has not been removed. If a program failed in year 1, so again, 2017, your program has a failing rate, and you get a no result in year 2. So let's say in the second year you didn't have at least 30 students, even in an expanded cohort, and the department just didn't calculate rates. Again, you would still have to make disclosures, right? Because even though you had a no result, you could fail the subsequent year, and that would be 2 out of 3 consecutive years. Now let's say, I don't have this example here, but let's say you're in the zone in year 1, or for that matter, you're in the zone 2 years in a row. You do not have to make the GE warning disclosure. okay? Because it's only if you have the possibility of becoming ineligible in the subsequent year, right? And you have to be in the zone 4 years in a row before you would lose eligibility. So even if you're in the zone in year 1 or in the zone in year 2, you don't have to make those warnings. So among other things, that's a pretty big difference between being in the zone and actually failing in year 1. Finally, the last example here, if a program fails in year 1 and then passes 2 years in a row, at that point you should be able to stop making the warnings, because if you've passed 2 years in a row, there is no way in the subsequent year that you could lose eligibility. If you failed again, it would be 2 out of 4 consecutive years, not 3 consecutive years, right? Doesn't the department understand that the GE warning will harm enrollments? In other words, you're making us do something that's going to kill our program before we even have a chance to better our rates. The department does get it, and this is what they said. This was in the preamble to the final regulations, and I just put it in here in full for a couple of reasons. One, I wanted to demonstrate their thinking, and two, I wanted to highlight a particular phrase here. We believe that ensuring that students have this information is necessary, even if it may be more difficult for programs that must issue student warnings to attract and retain students. Institutions may mitigate the impact of the warnings on student enrollment by offering meaningful assurances and alternatives to the students who enroll in or remain enrolled in a program subject to the student warning requirements. So there are two really important points here, I think. The first is the department understands, and they are not willing to make any type of concession, right? They say, well, we're just sorry, but we still think the need to make the warning outweighs the potential damage to the institution, period. So that's their view. But the really important thing I want to highlight here is this second sentence. Institutions may mitigate the impact of the warnings on student enrollment by offering meaningful assurances and alternatives to students who are prospective students or current students. So not only is the department acknowledging, they are just shy of endorsing the idea that institutions would package the student warning with assurances, right, and alternatives. So they're not saying you have to give this student warning, this canned language out, and you can't say anything else to the student. To the contrary, they are saying, look, if you can come up with assurances that you can make or alternative arrangements that will make the student warning more palatable or increase the likelihood that these folks will stick around, you can do that. Right? And that's a really important point. Frequently, when I work with folks and we're dealing with required disclosures, all the different kinds of consumer information requirements, you know, all the things that you have to say in the Clery Act or the financial aid shopping sheet, or, you know, pursuant to some MOU you have with the Department of Defense, maybe your creditor or your state requires you to say certain things. Frequently, folks will be frustrated about the thing they have to say and the fact that they can't change that specific language or disclosure that has to be made. But what often is missed is this idea that you can package that disclosure with explanations and assurances like the department is referencing here, right? So you may have to present some rate that your state makes you calculate, but you can say, this is how the state makes us calculate this rate. We do not think it's representative, right? If you would like to discuss with us what we think an accurate rate would be, et cetera, I mean, that's getting pretty aggressive, but the point is you could make things, you can add clarifying statements, and you can try to explain how the rate was calculated, and if you think that there's something about that calculation that doesn't make sense, you can try to point that out in the accompanying language, right? So it gives you a way to add some context and assurance, and frequently that is permissible, and here the department is even saying, you know, you can't say anything that's inaccurate or inappropriate, but they are acknowledging that there is an opportunity to package this with these assurances and these alternative arrangements, and acknowledging that that may be and is, in fact, an acceptable way for an institution to try to mitigate the damage of the disclosure. So that's a really important point that I hope folks will take to heart. So what can you do to manage the warnings? Okay. These are just some thoughts that I had, and there may be others, certainly, that you all have. I think the most important thing is that you're thinking this through and going through the exercise of trying to decide what you can do potentially to mitigate the damage. So first of all, take the department's advice to heart, right? That's what I was just saying. Consider whether there are assurances, alternatives that you can offer prospective and current students. So what do I mean by that? Could you offer a discount to students who might be enrolled at the time of the Title IV loss? Right? So maybe you can say, look, if you're enrolled and you've got less than a term left and you want to complete, we'll offer a 50% discount on the tuition. I mean, make sure that's okay with your state and your creditor, those kinds of things. But the point is, you might be able to offer them a financial incentive or some sort of break, right, to finish the program and stay enrolled. And maybe that cuts into your margin, right, but there's enough margin left that it's a sensible approach. Could you discount for prospective students based on their willingness to enroll at a time that Title IV loss is a possibility? If you really wanted to get creative, and you should talk to your attorney or compliance folks about your risk tolerance here, but you might suggest that you would offer someone some sort of rebate or discount to a prospective student in the event Title IV eligibility was lost, right? But that discount or rebate would not be available if Title IV eligibility remained in place. Right? So that way, if you think you've got a strong likelihood that you're not going to lose eligibility, you're saying to them, look, I think you're going to get to have those Title IV loans because we'll work hard and our DE rates have improved. But if you were to lose them and stay enrolled, we're willing to give you this discount on whatever the remainder would be. And that way, you're mitigating your risk to some extent, right? But if you're able to improve your DE rates, you're not actually out whatever that discount would be. I mean, there is room here to be creative. Again, taking into account your own risk tolerance. But this is the kind of alternative or assurance that I think is available. The other thing is you can let students know what you think the likelihood is that your DE rates are going to be problematic or you're going to lose that Title IV eligibility. Now, you need to make very sure that you are being clear that you cannot guarantee it. Right? That but you can make that type of statement in the context of saying, our expectation or our strong hope or we are working very hard to ensure that kind of thing, right? And you need to be complete and accurate and all those kinds of things. But you can let them know, look, we've worked hard and our economics changed and we think there's a strong likelihood that we will be passing next year and we will not lose Title IV. Maybe you don't want to have that conversation and that's more detailed than you want to offer, but that's the type of assurance that might be of use to you and you might want to contemplate. Take advantage of the opportunity, again, to package and present the GE warnings in the context of appropriate assurances. That's basically what I was just talking about. So the other thing, I just talked about appropriately representing your expectations. The first bullet here, could you offer seamless transfer to another program or institution if Title IV is lost? And that gets back to, what the department was referring to earlier, but maybe you can tell them up front, and this might be something you would want to tell a prospective student, even though it's not required as part of the content for the warning for prospective students. You still might want to say, if for some reason we lost Title IV in our, electrical program, you would be able to transfer all your credits seamlessly into our HVAC program if that would be of interest to you, and that program does not have any issue. Right? And that's the kind of thing that might say, oh, well, those are both cool. I like both those programs, so I'm willing to start the electrical since I know that I could do that. Again, that's the kind of creative sort of packaging and options that you want to let them know because it may be meaningful to them and it may make tolerating the risk of Title IV loss acceptable to them. Take the time to consider how best to integrate the GE warning into the admissions process. So, how do you want to make that initial GE warning? Right? Do you want to make it and then try to enroll within the next 27 days so you don't have to make it again? Do you want to do it via phone and figure out a way to record that was done, or do you just want folks in the context of a phone conversation to immediately send it out via email so that you never do an initial contact or first contact warning orally and you're always trying to do it in writing so you only have to make it once? If students typically enroll in person, putting a mechanism in place to ensure that you're distributing the warning in advance of the on-site appointment. So we talked about that kind of stuff. But, you can look at your admissions protocol and figure out what makes sense and figure out how you want to maybe alter your processes for a program that might be in this boat so that you're making these warnings as seamlessly as possible. Also, you might need to update related internal checklists, workflows, training, and disclosure documents for your admissions folks. Work out smooth methods for tracking and providing distribution of the GE warning. You could do this in a lot of different ways. The most obvious is to get a copy of a signed disclosure in a student's file, right? So you have your warning and it's got some sort of student signature on it, and then you just get them to sign it, you make a copy, and you put it back in the file. And then it's there. If you're doing it via email, you ask them to send it back just like you would an enrollment agreement or something like that if you're doing that electronically. You could also include it as a pre-enrollment checklist item for those of you guys that have pre-enrollment checklists. checklist, which I strongly recommend. So among the other things that you have them say that happened before they enrolled, one of the things they would check off is, yes, I received a written GE warning, more than 3 days before I enrolled. You could have, if you're doing a big group, you could have them all sign a roster, so at the top it would just say something like, all these folks got the GE warning in writing and at this, session, and they would all sign it. That might be particularly good for current and enrolled students. Although, again, the most conservative approach is just have everybody get a copy of the disclosure document into everybody's file. And then that also will make it easiest if the department, and I have a high level of confidence this will show up in program reviews and other reviews down the line, maybe the department's new enforcement unit, when they do investigations. One of the things they may be looking at is the timing between the disclosure and the actual date on an enrollment agreement, or the date, if you're a nonprofit, that, a registration was processed or something like that. And so you want to have some way to be able to show that the dates work and are within these time frames. Right? So whatever you devise, you want to make sure that you've got a way of recording this. And remember, if you do some of these, like with the email, you've got to get a written acknowledgement of receipt anyway. But preferably the method should include the student signature and not just an electronic note that the distribution occurred. So in other words, if you're running some sort of, you've got a student management system, I don't think a simple note put in input by an admissions officer that sent GE warning out today is going to do the trick. That, I would not want to rely on that. Again, you have to have an acknowledgement of receipt, so you're going to need that somewhere if you're distributing it when you do the written, whether it's in hand or really even or via email. But I like the idea, no matter what, of just always trying to get a signed copy of this thing and get it into the file if you can. I think that's the safest approach. Train your admissions reps to handle the GE warning inquiries accurately, completely, and smoothly, right? You don't want to just throw this at them in February of 2017 and say, hey, you got to start making this disclosure, because you don't know what they're going to say when folks start asking about it. And what you really do not want them to say is, don't worry about this, it's really no big deal, we'll be fine, right? So you need to talk with your admissions personnel and the folks, third parties, recruiters and marketers who are working on your behalf, to make sure that when they're handing this thing out, they're ready to answer questions about it in a way that is accurate and complete and also smooth, right? You want it to work smoothly. So spend some time training them in advance and make sure that they've got the materials and that they understand exactly what they're supposed to do. Again, coordinate with marketing agents in advance to ensure proper disclosure. So if you've got third parties who are going to be responsible for doing this. And that's it. So that brings us to our GE resources. Just really quickly, there's not a lot yet on the GE warnings because we're still a year and change out from this having to happen. So for that reason, typically I have not included a link to the final regs, but there is some discussion in that preamble. So there's a link here to the October 2014 Federal Register. And then also in June 2015, the department had one Dear Colleague where they had a brief discussion about GE warnings. And these are active links, again, that you can follow once you get this presentation. Here's more generally the GE resources from the department, most of which are housed on the Gainful Employment Information page. All these are active links. Obviously, we offer this webinar series, and we'll let you know in a few weeks when all the recordings are up and active. We'll send that to you, and you are getting the slides for each of these presentations. If you have not, for some reason, let us know. We've got our Reg Education Higher Ed Law and Policy blog, where we occasionally write about gainful employment. And then the desk guide, which I've talked about in prior webinars, which focuses on how to project debt-to-earnings rates. It also has been distributed and will continue to distribute it each time we send out the slides for each one of these presentations. Thanks, everybody, for your time, and look forward to speaking with you and connecting with you next week.